Okay, good morning, everybody. We're going to let all of you join us, so just give us a minute and we will get started. We being me, Neil Kalin, my co-host, Michael Simkin, and our guest today, Ben Lee. So let's just give everybody another minute. I got 12:01. We'll give everybody another minute. We'll get started, and anybody who comes in late will just miss our wonderful introductions and little fun facts today. Okay, Michael. Well, it looks like our participant list has stopped going up, so we are ready to go. Good afternoon, everybody, and welcome to another monthly issue of What's Up with Us, the real property law section discussion of cases of interest in the real estate field. And we always try to have a very interesting guest to talk to us about real estate law, in this case, real estate practice. And we're going to get into that and Michael in just a minute. Let's get started. I'll show you our agenda. Here we go. So first thing is going to talk about it's April, and I saw something I thought was really interesting. If you are the hungry or the food type, I know you're hungry for knowledge. That's why you are here at What's Up with Us. You can see we've got 4 cases we're going to talk about. One about attorney's fees when you're seeking rescission of a PACE contract. And I don't know if our guest has seen those PACE contracts in his real estate practice before. If so, you're welcome to join us and talk about that. An injury case. Then we've got another injury case, Whitehead. And then we're going to talk about suing for trade secret violations. I know, not exactly real estate, but a lot of you do business law as well. So we're gonna see if that has any kind of meaning for you. Update on the Restaurant Association versus Berkeley. We've talked about that before, the gas connection ban. And then I want to remind everybody of some upcoming events that we have at the real property law section. So let's just jump in about, are you hungry? So I found this interesting site about various food days in the month of April, National Food Days. It's absolutely amazing. Being a Chicago native, I'm really sorry that I missed April 5th, Deep Dish Pizza Day. And I'm also upset that I missed the 13th, Peach Cobbler Day, my favorite dessert. But I'm glad that I still have time for Prime Rib Day and Oatmeal Cookie Day.
But Neil, I have a question. How come there are
Yeah.
2 beer days? There's
You didn't read it carefully. One is
Eve
New Beer's Eve, and the other is Beer Day. I guess the beer lobby, got 2 national days, right? New Beer's Eve and Beer Day. So that's why we got 2 there. Oh, you know what I see? Here we go. Today, the 18th, is also National Velociraptor Day. You're probably wondering why I had those little pictures there on the side. And it's National High Five Day. So some interesting facts for our members, our audience today. And let's jump right in to our first case of the day, Andrade versus Western Riverside Council of Governments. All right. So what happened here? So Andrade is a homeowner, and Andrade discovered that, lo and behold, some contractor signed them up for a PACE loan. So PACE loans are those government programs that subsidize basically energy efficient improvements to a home. And there is a lien on the home, and the lien gets paid off essentially through property taxes, right? So it's not your traditional lien, which is why you see the Western Riverside Council of Governments, okay, which is one of the defendants, because it all essentially goes through a government entity. So poor Andrade, found out about this. Andrade's name was forged on a lien. Andrade was forced to bring suit to try to get the lien removed. How did Andrade find out about this? Well, Andrade's property taxes went up because of the improvements that supposedly were made to the property. So there could be great things about getting a PACE lien or PACE loan to make an improvements, but we have heard, at least I have heard, that there's been a number of problems associated with them. And unfortunately for Andrade, this was one of them. So Andrade brought this action, sought rescission of the agreements, declaration that they were unenforceable, filed a complaint with the Department of Financial Protection and Innovation, formerly the Department of Business Oversight. They investigated, they found out there was fraud, got the lien released, got the overpaid property taxes back, and Andrade filed a motion for attorney's fees and cost, saying, wait a minute, there was supposedly this agreement that I did not sign. The agreement had an attorney's fees clause in it. I want to recover my attorney's fees for trying to get this lien removed. Trial court said, no, no, no. The fee clause was limited to only judicial foreclosure actions. But the trial court said, but you are entitled to costs as a prevailing party. You're just not entitled to attorney's fees under that invalid contract. Andrade appealed. The appellate court said, well, wait a minute, under 1717, and Michael, I imagine you probably have some experience with this. It does not matter if the reason for the attorney's fees are narrowly drawn or broadly drawn, they're going to apply to the entire contract anyway. And a person who brought an action to say the contract was invalid is nonetheless entitled to the advantages of 1717, even if they were successful in having a court determine that the contract was invalid. The court said, you know what, we're going to have to remand, though, the appellate court, we're going to have to remand, and the trial court is going to have to make a determination as to whether Andrade was the prevailing party for purposes of attorney's fees. The court even made some kind of comment like, it's unlikely that if they were the prevailing party for cost, that they would not be the prevailing party for attorney's fees, but that's going to be up for the trial court to decide. What do you say, Michael?
I think someone's going to get an award of attorney's fees in this case. Yeah, this happens a lot, but this PACE thing, right? I get a lot of calls from homeowners, they're usually elderly or not the most sophisticated, and they get sucked into these PACE contracts, and it's very sad. I mean, maybe I'll get some hate mail from the PACE companies, but I don't know if it really is such a good deal. I mean, I think there's a lot of potential for abuse by those contractors.
Well, I told you in my practice with the California Association of Realtors, I've heard of a lot of examples of abuse, which again is not to disparage the entire industry, but there seem to be a lot of bad characters in that industry. And then if your approach with somebody legitimate, you want to examine those contracts, because you might be better off just getting a loan from a bank to pay for whatever improvement that you were trying to do to your house to make your house, greener or more energy efficient. So again, just like anything else, a serious contract involves significant items, involves improvements to the real estate that are not easily removed. So you need to take them seriously and be careful anytime you get involved.
Nothing is free.
Nothing is free, right? Yeah, and that's how a lot of these things are sold, which is, oh, you don't have to pay it back. Well, the reality is you do have to pay it back, but it's being added on to your property tax bill if it's going through one of these type of programs. So yes, you're right. Nothing is free, and everybody should look out for themselves. And it's good to see this case that the victim here is going to be probably entitled to recover their attorney's fees in getting this fraudulent or forged contract and lien removed from title. Okay, let's go on then. That one was pretty quick. I don't think we've ever done a case that fast. So we're going to go on to Howard versus Acor Management, and this is a liability case involving property, and we've done some liability cases in the past. We did one where there was a fitness center, and I remember this one where the light was out in the spa, and unfortunately the person who was in the spa, there was no light when the door was closed, stumbled, and of course in the spa you've got that hot mechanism, right, with the rocks, and apparently fell right into it and was seriously injured, right? So we got to be concerned about property liability cases. So let's take a look at this one and see what happens here. We had Howard was a guest at the Sofitel, Los Angeles.
Is that Sofitel?
Sofitel. Okay,
Up in there.
I'm more of a a Hampton Inn kind of person. So what do I know about Sofitel hotels there in Beverly Hills? I was staying there for a few days. There was another guest as well. I don't remember if the guest was a spouse or just a friend. They're out for the day. Came back, decided to take a shower. The turned on the water. The water was spraying into her face. She reached for the handheld shower. It broke, cut her hand. She fell back onto her tailbone, and all we know is resulting in severe injuries. Well, yeah, you're in the shower, you fall back in your tailbone. I can understand there might be some severe injuries. What did Howard do? Howard sued the hotel and the management company. That's where you have Acor Management up there in the title of this case. Howard made some allegations. Howard said, well, clearly what must have happened was the housekeeper broke the handheld shower and put it back in place and never told the hotel about what was done. Howard had an expert who sort of opined that same way, but Howard never deposed the housekeeper, even though the hotel did offer to make the housekeeper available for a deposition. The hotel settled, the management company did not. Acor filed a motion for summary judgment and said, well, wait a minute, there's nothing was proved here. There's no evidence that we were negligent, and the concept of res est loquitur does not apply in this case. And so the trial court said, yeah, you know what? We agree with you. There was insufficient evidence of negligence. So I think that's the key here, is whether there was actual evidence, right? And there was expert testimony, and the expert testimony, the court said, that was all just a bunch of conclusory statements, inadmissible statements about legal standards, and it was purely speculative. So really, what was the expert testifying about? Not really much of anything. Of course, the case was appealed. The summary judgment granting was appealed. The appellate decision affirmed the granting of the motion for summary judgment. They looked at a few different issues. They said, well, one of the claims had to do with constructive knowledge. It was never presented to the court. Forget it. We're just deeming that waived. Well, what about actual or imputed knowledge, right? So here there was, let's just assume there was a broken shower head, right? Was in this case, the management company responsible for that? Did they have actual knowledge? Well, if it was proven that the housekeeper broke the shower head or the handheld shower head, or was aware the handheld shower head was broken, well, then that knowledge would be imputed to the hotel and the management company. But the court went on to say things like, well, we can draw evidence, we could draw inferences from evidence, not from possibility, not from mere speculation about what might have potentially happened. They said, you know what? it could be, and maybe it's just as likely that when the water was spraying in Howard's face, that Howard grabbed the handle, fell back when grabbing the handle, and that's what caused it to break. So maybe, Howard was the one who was negligent, and in the absence of any evidence establishing that the housekeeper was the one who caused it, we're actually going to get rid of that claim as well. They addressed, expert testimony about what could really be done. And then one of Howard's claims was, well, hey, res ipsa loquitur applies here. Well, what are the three requirements that are necessary? The accident was a kind that ordinarily does not occur absent someone's negligence. Well, maybe it occurred because Howard simply slipped, not necessarily that there was negligence involved. The instrumentality of harm was within the defendants, that would be the hotel's exclusive control. And the court said, well, that's not true. It was not exclusively within their control. Howard had access to that handheld wand as well. And three, the plaintiff did not voluntarily contribute to the harm. And so we don't know. What do you think about this premises liability case, Michael?
Okay, I keep thinking, you remember it was like an advertisement about res ipsa loquitur and the rebuttable presumption. Remember that was Larry Parker ad or some ad a long time ago? Well, what's res ipsa loquitur? It means this must have caused the accident. And what happened here is the court wasn't persuaded that this part of the shower could only have been damaged due to the hotel's negligence. You couldn't tie these things together. I mean, I don't know, how do you just say that this piece of the shower exploded spontaneously? They had no evidence of that. That's why the plaintiff lost.
And Michael, you're a trial attorney. I'm not. So the issue here is an expert was opining about what could have happened. Is that enough for evidence in a normal case?
Not for the court. You saw in the opinion, it says exactly what the court thought of the expert. Not too much, right? They went through the evidentiary objections that were sustained and everything else. Now, okay, I have to watch myself here. I happen to know the plaintiff's lawyer in this case. He is an amazing guy. He is not just the nicest guy, but he's very, very smart, I think. I think he's a good talker. He's a great guy. He's a kind of now he's quite well known. But if I'm gonna be that, second guessing guy here, I don't know why they kept talking about res ipsa. I don't see how that could be the theory here.
So Michael, when you bring in an expert for a case that you're trying, and maybe it's not a premises liability case, what do you want the expert to do to help build your case?
Oh, you need credibility. Okay, so I have this right now in a construction defect case. And my expert, first, when I use experts, I don't care. I happen to have it on a plaintiff case, which I'm usually kind of defense oriented, I guess. But I use a defense expert. So I like to use experts that I know the other side could consider. It makes it just more, balanced, I think. But even talking about it with the expert, one of the things that comes up a lot, especially for plaintiffs, they have a list. They want like every little teeny thing. So sometimes you have like this construction defect case. Yeah, there's some like cracks, but so what? These are like minor. There's a much larger issue going on. So I was talking to my expert, and it's like, well, you're right, and probably those cracks could have been exacerbated by this other issue, but why talk about it? Because we don't want them to focus on little things, because the other side is going to say, who cares about that? That's nothing. Let's just focus on what's important. And these experts, they have to focus on what really is important, and they have to think about it. They got to think about it not from their point of view, but from the defense point of view, and and vice versa. And you got to consider what else is there, or what's the big thing. And I mean, I just don't understand, especially their expert, when they said in this opinion here, how the expert apparently never even examined the actual broken shower wand and just looked at a picture, okay? So I'm presuming that the actual broken piece, physically someone had it, okay? And I don't know why their expert didn't look at it. I mean, there are just so many, there are little things like that. That is what the court wants to say, common sense. And one of the things that comes up in cases, and it comes up if you're writing a brief, you know, you're writing something and you're editing it and you're looking at the same words, the same paragraphs, the same argument over and over and over, and your eyes are glossing over things that if you give it to some new eyes to read, you pick up on not just grammatical mistakes, but some logical issues. Same thing with the case. You know, you're living the case, you get, you know, you feel some empathy towards people, but you're overlooking that, wow, this also happened, but you forgot about it, or you didn't notice it, or you thought it's nothing and you focused on something else. You have to consider everything, the totality. And that's one of the crazy things, especially with jury trials. I've been so completely surprised by juries. I enjoy, well, I sometimes don't enjoy it, but when you talk to the jurors afterwards, if they'll talk to you, some of these jurors after the case, they're out the door, like they're out of there. They don't like the case, they're gone. Some of them will walk up to you and they'll say, you know, we really like your title. They really like this part, or they were sympathetic for something. Others will walk up and say, what the hell were you thinking? Okay. I've just seen all types. And you really have to take a step back and look at your case. And these experts, they don't just take an expert blindly. You know, it's kind of like those home inspectors that you get. Like our special guest today, Ben Lee, will talk about, he refers people to home inspections. You know, these home inspectors have a checklist. It's computer generated, and you get this beautiful 40-page report. But you got to look behind the scenes. Like, you know, they're clicking things off, but maybe there's something in there. And these experts, they have to think about the totality of the case. And that's one thing I have seen it before. It doesn't happen. And I'm very slow. I'm very pedantic. I just like really try to step back when I look at a statement of facts from the expert in particular, or when I look at people don't read contracts. I'm just amazed how often people don't read their own contracts. You'd be amazed how far it goes sometimes, these cases.
Well,
Anyway.
I'm sure our guest can speak a lot about that too.
Yeah.
Michael, I've got a question for a quick answer, and then I'm going to make an announcement that I forgot to make at the beginning. And because you said you know the plaintiff's attorney here, I'm not going to ask you to second guess the plaintiff's attorney, but it seemed to me, just reading through this, I could not understand why not depose the critical witness, which was the housekeeper. Is there a time for one of your cases where you say, I'm not going to depose the most critical witness in this case?
Okay, so I actually, so I had this come up last week, and actually my daughter was, you know, watching what was going on, and she goes, Pop, you just like, I don't know what she used, like outfox him, says, you knew what he was going to say before he said it. And that's what you always tell me. I mean, a long time ago, I don't know if it was a TV show or something, I learned that attorneys have to know the answer to the question before you ask it, right?
Yeah.
And so I don't know why you wouldn't depose the obvious person to see what they say. Because in the deposition, like, I can twist anything. I'm a lawyer, right? You can spin almost anything. So, but if you don't know what's coming at you, how do you know how to deflect it, right? So I don't know. And this lawyer, he's a great guy. I really like him a lot. I'm going to see him in August. Maybe I'll call him. You know what? I think I'm going to call him up. I'm going to ask him about this case. I don't know
Okay.
what happened there. Maybe I'll have him come on as a guest. We could do that too.
That would be great. Okay, we're going to move on to our next segment, which is our guest. But before I do, I see there's a lot more audience members than there were when we started right at noon. And just to remind everybody that as of January of this year, What's Up With Us is available for free attorney MCLE credit. So you've registered, you've signed on today. By tomorrow, you should get your MCLE certificate from the California Lawyers Association. We were really excited, Michael and I, that these programs, these 1-hour programs, are now available for MCLE credit. So get them, save them. You know, when your renewal comes up in January, whatever, depending on the first letter of your last name, save these, and we're glad to help you out. So with that, we're going to move on, and we're going to move on to talking to Ben Lee. So, Michael, why don't you take the lead on interviewing Ben?
Sure. So Ben Lee is unique. He's both a lawyer and a broker, but at some point in time, we're going to ask him, he saw the light to get out of the lawyer rat race and do something productive, like help people buy and sell homes. So Ben,
yes,
and
tell us a little bit
very
about your life.
successfully, I may add, reading up about Ben for this interview. So go ahead, Mike.
thank you. Thanks. Nice to meet you guys. Nice to be on the show. And it's great to hear about cases. It's been probably 20 years since I've heard about cases. So I don't know if that makes anybody jealous or but I no longer really spend a lot of time keeping up on that stuff. I did, yes, get out of the law practice. I only practiced for about 3.5 years. And then I kind of transitioned into more of an entrepreneurial world. So, Michael, do you have any questions? I know Michael from living in my neighborhood, and we've talked real estate many, many times. I've helped out a client of his. So, talk to me. How can I help?
Well, what I want to ask is, so I know you're really good in your area as a broker, but are there skills you think specifically from being a lawyer that you use as a broker, or is broker a different world? Because I know brokers have to make a deal. Lawyers tend to tear things apart. You have to put it together.
Yeah, that's a very good question. I think when I started in this business, I was a young lawyer, and I, was full of piss and vinegar, and I thought I knew everything, and I thought I could do this. This is an easy business that, my legal skills would translate. And I was practicing as a real estate lawyer, so I was competent with just general concepts and running escrows, etc. So when I got into selling real estate, I had to retrain my brain to some degree, because as an attorney, you are constantly looking at the downside. You're looking at the potential risk for a client, for yourself. Whereas as a broker, like you completely accurately put, you need to make a deal. You need to be working on making the deal and bringing people together. In fact, that really is what you're hired to do. You are also, as a fiduciary, you are responsible for protecting their interests and making sure that everything is kosher with the deal. But you are absolutely hired to make the deal for them, for everybody, for yourself, for the whole world. You have to make a deal. And so the whole downside risk and the liability, to some degree, you always have that in mind. You always have to keep that covered. But I think it's just a different way of thinking of things. And I do think that my skills as an attorney have really, my limited skills, I didn't practice for many, many decades or anything, but I think that the limited skills helped me in a lot of ways protect my clients instinctively. I was able to sort of see potential pitfalls in any transaction and sort of address them as we go. Ideally, now then the broker part comes in, you have to address them in sort of a non-reactive, non-alarmist way. And just, if there's a problem, you've got to figure out how to get through it, how to correct it, how to, nullify the problem, or at least address the problem and make sure everyone understands the problem and the implications. So I think being an attorney really helps me a lot.
Hey, Ben, I've got a question for you.
Yeah.
Actually, two things. One is, you know, I did not put your website address up on the screen, and just in case somebody wants to read up about you, find out more about you,
Sure.
maybe they're interested in buying or selling. So first, you know, do you have a general area that you practice, geographic area? And two, why don't you just mention, so for our audience, your website in case anybody wants to look you up?
Thank you. Absolutely. You guys are welcome to call me anytime for really any reason. I'm always happy to talk about my business. My website is benleeproperties.com. Ben Lee was taken by a dump truck and roll-off company in, I think, Michigan. So I got Ben Lee Properties, and that's my website. And you're welcome to call me on my work line, which is listed on the screen, or on my cell phone, which is pretty easily obtainable. Yeah. So what areas do I work in? So my office is in Beverly Hills. So I do handle Beverly Hills property, but I kind of go from West Hollywood all the way to the beach. I grew up in Santa Monica and then in Malibu. So I have a very good knowledge and client base, Santa Monica and Malibu and Palisades. My wife grew up in Brentwood. So all of the West Side, I do handle all of the West Side of Los Angeles. I have an area where I market to, and they call it in my business farming. I don't know if they call it the same in the attorney business. You guys market that way, but I have what's called a farm in my business, which is a list of addresses that I've chosen to market to, you know, once a month for the last almost 20 years. So that area is essentially Beverlywood, Cheviot Hills, and Westwood. So it's about 10,000 homes, and that is sort of a regular and continuous stream of phone calls that I get from the marketing, which is quite successful. And then you know, I do internet marketing, and I have a property coming on the beach in Santa Monica. So I have another property coming in Santa Monica Canyon. So I'll work all over, if that makes sense.
All right. So I have a legal question for you.
Yes.
Okay, sort of a legal question. In real estate, it is permissible for a broker to act as a dual agent, either individually or through other licensees working through the firm.
Mm-hmm.
When you find yourself in that situation, is there anything that you do different? Do you have the parties sign any kind of waiver, any kind of, you know, acknowledgement, any kind of disclosure, or are you just super triple careful about what you do?
All of those things. I have people sign disclosure, which is a disclosure for representation, or it's really called the disclosure for possible representation of more than one client. And that is a disclosure which contemplates having a dual representative relationship, which is absolutely allowable in California. So there are some states, it's my understanding, that do not allow a dual representation. But here we do. So that is a part of my business. I am ultra careful when I do have a dual representation. And what I do find, and this is actually something that I think my law school background helps me with a lot, because while I was in law school, I went to Loyola in Los Angeles. I took a few different mediation ADR type classes. And what I found about those is they were more about hearing people and trying to understand their core interests. That was really interesting to me, actually. And I think in negotiating real estate contracts, that also applies, because I do believe, look, price is like, everyone on this call is going to say, what do you mean dual interest? Price is the only thing. It's really not in these arrangements. There's a lot of psychology. There is a lot of, I'm seeing an Amazon truck pull up right now, which means my dogs might bark. So forgive me if they do. That happens when I work from home. But, you know, I find that people do have core, you know, somebody might not want to market their property. Somebody might want to stay in their property after the close date. Somebody might want to keep certain lamp fixtures. I mean, there's so many different objectives that buyers and sellers have. You know, a buyer may want a longer close of escrow. You know, it's really an interesting thing that when you hit those other core interests of each party, you can, you know, flex on price. I mean, price may not be the most important thing. So I think as a dual representative, I very frequently can manage the expectations of all parties and get to the point where everybody is happy. There's a great book called Getting to Yes, which is a Harvard Business School study about negotiation. I think it's really great. There's a chapter on that. So I think it's really an interesting part of my business.
I think
Michael,
communication
we
is.
only have a few minutes left for the interview. So is there something else you want to know?
Well, I have an observation, and
Yeah.
I think Ben would probably be really good at this. It's communication, because I think 98% of all civil disputes are from failure to communicate. And when there's a buyer and a seller in a real estate transaction, like you said, I thought that stove came with it, or I thought that really special lamp that happens to be some, like, you know, $15,000 art piece came because it's attached to the wall or something. And there's a lot of assumptions people make, and maybe as a lawyer, you know that you can't assume things, and you probably, you know, that's one of the things that I see coming up.
Yeah, those are definitely. I mean, communication is a huge issue, and I think right when I got started, I read somewhere, you know, deliver good news fast and bad news faster. I think the point of really being open about what's happening and why it's happening, and just hitting any problem. For example, let's say the seller says, well, I had no idea that $15,000 lamp would be included. Why would it? My grandma gave me that lamp, you know, and hey, it was included because we didn't exclude it because you didn't tell me that you wanted to keep it or whatever it is. And so you're going to have to get, you know, washer dryer, whatever it is. You are going to have to deal with, there come the dogs, but you are going to have to deal with, hold on one second, I'm so sorry. Yeah, you are going to have to communicate effectively and talk through any problem that, you know, that you can anticipate also. I mean, the more problems you anticipate, the less you have. So I think communication is definitely the biggest part of my business that, you know, I can't do right now with the dogs barking, but it is probably the most important part of my business.
All right. Well, thank you.
So no problem.
Yeah, Michael, and thank you for communicating with us and our audience today.
Yeah.
We have a couple more cases we're going to discuss. You're welcome to hang out and pipe in if you want, and if you have to go and address your dogs or your delivery, you're welcome to do that too.
Delivery is gone, so I'm going to sit around and sorry, they just came at an inopportune time. But absolutely, if any of you on this call, I can't see any of you, but if anybody, I'll assume you're there. If any of you have any questions or, you know, client-related issues, you guys are welcome to get in touch with me. Thank you for having me. Go and talk about your cases. Hopefully, I'll see you soon.
All right. Thank you.
Thank you.
All right. So let's talk about Whitehead versus City of Oakland. And here we have another injury case. In this case, it was a bicycle injury.
That's so embarrassing.
So Ben, I'll ask you to put yourself on mute, please, unless you're ready to chime in. So here we have a bicycle injury case. A person was participating in preparation for a big bike ride, and the bike ride is from San Francisco down to LA. There's practice runs that don't do the whole thing, and here we have the situation. Whitehead was in the practice run beforehand, signed a waiver and a release. Notice that the waiver released the owners and lessors of the course or facilities used in the event. Well, they're riding on public streets. So who has those facilities? The city. You know, unfortunately, Whitehead hit a pothole, flipped over. I've had that experience myself, wound up separating my shoulder after law school. Fortunately, you know, did not have anything more serious, but it could be more serious. So, you know, what did Whitehead do? Whitehead, you know, brought an action, you know, for the injury that White had suffered. Oakland brought a motion for summary judgment. The trial court granted Oakland's motion for summary judgment based on the waiver release. The plaintiff appealed, said, well, wait a minute, that pothole was a dangerous condition and that waiver was invalid because I was involved in something that concerned the public interest, and you can't have a waiver that's effective for something that affects the public interest. The appellate court saw it the same way as the trial court, affirmed the granting of the motion for summary judgment, and said, you know what, this activity that you were involved in, this ride, this, you know, few hundred mile ride and practicing for it, that's just a recreational activity. There's nothing inherently about that that is in the public interest. You don't have to do a ride if you don't want to. The public is not inherently benefited by this ride. So, you know, sorry, Whitehead. To me, Michael, what was really interesting here is in a footnote, you have this down at the bottom of the screen, the court said, our opinion is limited to the facts before us and should not be read as opining on the validity of a release in other contexts. And it gave examples. It's like, I don't know why the court felt the need to do that. All opinions are limited to the facts before them, right? And should not be read as opining beyond. Now, unless you have a Supreme Court decision where they're trying to reach some overarching public policy consideration with their opinion. So I thought it was unusual that a court wanted to emphasize that this opinion was limited to the facts. I just thought that's a general rule of law. What about you, Mike?
I agree. It's, you know, that's the unique thing about our system is it's very fact dependent. You know, bad facts create bad law. Okay. And I've seen it a lot, in particular with easement cases and prescriptive easement cases specifically. But here, you know, I'm doing my second guessing on this. And okay, so the charity, the AIDS life cycle, in the opinion, they talked about, you know, this isn't like a little 5-mile race. This is a long distance race. And it talked about how they have
500 miles, something like that. Yeah.
It's crazy. It's like to Los Angeles. So
Right.
they have a support gear person that follows the riders by a car to offer support. They have some sort of training system to train bike riding leaders that it says here, select cycling routes, okay, with specific start times and rest stops. And I'll tell you what I was thinking. I was thinking if the organizational entity, the charity, there's so much thought in where to have the route and how to support the riders. Shouldn't they be the ones trying to see, is the road, you know, paved? Does the road have potholes? Does the road go by someplace with a dangerous condition? You know, it looks like they didn't sue the charity. They only sued the city. And there's a lot of problems when you start suing, you know, government entity. Okay. It's really tough, you know. So the city has a lot of, I don't know, but with permits, ministerial rights to, you know, issue permits. Doesn't mean that just because they stamp your permit to build a house or they stamp the plans for the foundation or whatever, that's the best choice. You know, it's up to the contractor or the architect to make the best choice of how to build something, not the city who just stamps the plans, right? So I think that this pothole issue, I don't know, I would have, it would be kind of bad, but I would have sued the charity.
You know what? I did not see any evidence of that, and I don't know. I did not go beyond the case, so you know, to research it to see if there was some other action that was brought. You know, I imagine a lot of people don't want to sue, you know, a charitable organization that they're participating in, right? That I know in real estate, we tell people have a good relationship with your client. It's not going to necessarily prevent a lawsuit, but a client who likes you is going to be much less inclined to sue you than a client who doesn't like you. I see Ben pop back up with his picture. I don't know if you wanted to say something here, Ben. Take yourself off mute.
There we go. I'm off mute. We were talking about that a little earlier, and yeah, I think as long as you sort of communicate well and act in people's best interests, and if you're a likable person, if they actually like you, I think they're much less likely to sue. And like we talked about, this is a very liability in this business is always a concern. I think the more candid and transparent you are, the less likely you are to get sued by your clients.
And well, in this case,
go ahead, Michael. There was just a question for Ben, so I wanted to raise it, and then I'll let you finish up. The question, Ben, is this, and you weren't a lawyer for that long, but the question is selling and buying real estate ever as stressful as litigation? What do you think about that?
You know, I have a lot of litigators clients. I will give you a very honest answer, which is this is one of the most stressful careers that I think you can have. And I do think litigation might be comparable when you're in the heat of it, but it can be extremely stressful. You know, it's a roller coaster. It can be a daily roller coaster. And this is the type of business that I think the more wellness you can get into, the more meditation and exercise you get into is better. So it is a very shockingly stressful business.
Michael, you were going to say something?
I just wanted to go back to the case so people don't get misled about like what happened here. But, you know, these releases of liability, you know, they don't apply blanket to everything, you know, like gross negligence, you know, you can't release from that, and certain intentional acts. And these are designed, like they said, for recreational purposes. And they're trying to like tie this all together here. And I just see it, you know, not going to work against the city and the pothole. Oh,
okay.
So.
All right. Well, good. So let's go on. I think we'll make some quick work of our next case, which is applied medical. And yeah, we have a few minutes we could talk about this. And here's a case where there is an employer and an employee, and the employee left, and the employee, in this case, downloaded some trade secrets from the employer, took those trade secrets to the new employer. The old employer found out about it, of course, was not too happy about it, brought a lawsuit, sought an injunction against the former employee to stop any continued use of the misappropriation of the trade secrets. And you know, so then what did the employer want? The employer wanted their fees. And you look here, you see there was a lot of fees involved. I think it was just under $4 million in fees. But in the trial, it was found out what? It was found there was no damage to the former employer. There was no inherent benefit to the former employee. And it turns out that the information was somehow given back to the former employer, and that the new employer really did not make any use of it. So there was no inherent damage, but an injunction was granted. The former employer said, you know, I want my fees. This cost me a lot of money because of my former employee's activity. The motion for fees was granted, but you see it was really reduced. $4 million down to $550,000. Actually, both parties wound up appealing. The appellate court said, well, guess what? There was a misappropriation. You do not have to have damage to find that there was a misappropriation. And some of the tests are there on your screen. And the court said, well, guess what? Since equitable relief was granted, that enabled one essentially to be a winner of the case, and is entitled to collect their fees. I just threw up on the screen for you, since I knew we were having a real estate broker today. In the real estate context, there is an independent contractor agreement that CAR puts out. There is a paragraph in the independent contractor agreement, again, not employer-employee, right? A broker and an independent contractor salesperson, but a similar type relationship. And there is language in that independent contractor agreement protecting files and certain work product of the broker. So I just wanted to let you know it's more than just the employer-employee relationship where these kinds of things apply. Michael, do you want to say anything here?
This case is all about attorney's fees. It seems that the court had no problem about the injunction about, don't keep disclosing this or return whatever information the person took. But I didn't look deeply into this case, but $3.9 million of fees. And then there's a footnote number 7 that says something about the plaintiff did not include another $1.2 million in fees and $79,000 in costs that they chose to exclude from its fee motion. Okay, so we're talking over $5 million. I want to know what that information was that was so wrongful and what the guy did with it. It just had to be critical information for them to spend over $5 million in attorney's fees. It's crazy.
I agree with you there. That is really a huge disparity, right? When there's no damage and you're spending, as you say, over $5 million in fees. The appellate court, just to those of you who are just like kind of looking at the number, said that the trial court did make a mistake in having just a kind of a blanket reduction. It said there was 4 causes of action. They were only successful in one of them. So we're going to reduce the fees to only 25% of what was asked for in that total amount. The court said, no, if anything had related to the activity related to the injunction that was granted. So I'm guessing the fee award is going to go up, upon remand.
Well, also, one of the things about attorney's fees award is the law is pretty clear now. The trial court has an obligation to look at every line item on the bill and determine whether or not it was reasonable. They have to really go through it. And I know courts hate to do that. They tell you that. They usually encourage you, can you guys try to work out something on the fee motion? Because in a large case, you can generate your bill. My work is done hourly. So we have a very detailed, bill for people. And I present the bill to the court in the fee motion. And the court has to go line item by line item. And if I'm opposing it, I'm trying to say, well, look what they did. Either they redact it so you have no idea what it was, or that's secretary work maybe. But in this case, the appellate court also didn't like this mechanical, okay, we'll give you 75% because you went on this cause of action, but not these others. That's the other thing that happens. It used to be, I saw a lot of courts that I'm just take off 25%. I'll take off 50%. They do stuff like that. And they can't. They have to go line item by line item. But then again, how many people are going to appeal that? This case was just litigated like crazy, which leads me to something else. I'm currently in Toronto because, as you know, I'm now a Canadian lawyer too. And one of the things that I've learned is in Canada, you get fee awards if you win, period. Okay, in Canada, you win the case, you're getting your attorney's fees. You do a motion for that, not the American rule where you need a contract or a statute. And attorney's fees scare a lot of people. People don't file lawsuits because they don't want to lose, or they settle lawsuits because they don't want the attorney fee issue. In this applied case, it seemed like the court had no problem granting the injunction. So it seemed pretty clear the guy's wrongfully using this, information, yet they had to go all the way to the end, which is crazy to me. Okay, that may have been why the trial court wanted to give, a healthy amount of attorney's fees, because the trial judge probably thought this should have gone away very early on. This is just way overly litigated, although, to each their own. I guess if they can pay for it, make the lawyer happy.
I guess so. Okay, Michael, I'm gonna move on. I was gonna give an update on the restaurant ban case, and basically the city and the Restaurant Association reached an agreement that the city was not going to enforce their ban. I like the last line on what I have in your screen. Again, this is from the Restaurant Association. Every city and county in California that has passed a similar ordinance should follow their lead. Don't try to enforce these unenforceable bans. I kind of like that coming from the Restaurant Association. Let's see what's coming up next. Again, if you've got an idea for a webinar, a e-news article, a full, full law review type article for our journal, we got the contact information up there. Next month, May 17th, Michelle Lee is going to be putting on the first of a series on real estate transactions in Indian country. I happened to see, I got a copy of her PowerPoint presentation, really outstanding stuff. If you don't know a lot about Indian property, Indian law, and you have got a client, the client, is purchasing property, selling property, entering into transaction, with the tribe, you really need to attend this by Michelle Lee. She was a guest a few months ago on What's Up With Us. She's really put together a powerful presentation that lets you know what to look for, what the red flags are, what the ins and outs are of dealing with real property transactions, whether you're dealing with in an Indian tribe or Indian property. Really good stuff. Also, Brooke, if you're with me, I just found out just an hour ago that this is not only going to be a webinar, but if you happen to be in Sacramento, it's going to be a live event also. Brooke, how could somebody attend this live if they want to do so?
Yes, we're going to have a webinar and in-person feature. Michelle Lee will be here at the CLA offices. So when you go to register, if you would like to attend in person, go ahead and click that option. Spots are limited, so you want to go ahead and do that quickly. The other great thing going on is if you are a real property member and want to attend in person, the webinar will be free if you are a real property member and attend in person.
Hey, well, that's good stuff. We don't see a lot of that coming from the real property section. It's nice to know that you are open, that the section is open to different ways of getting the message across. And if you're in Sacramento, if you've got an hour, why not show up at the office and get your credit and meet Michelle Lee and do it for free. And if you're not in Sacramento, well, just do a webinar like we do everything else. I see we're running out of time here quickly, Michael. So I'm just going to remind everybody down at the bottom of your screen, next month we'll talk about the Supreme Court case of Sheets versus El Dorado, a takings case. I've seen a lot of information about it, but I'm just wondering, is it a big deal or is it really much ado about nothing? And we're going to talk about that next month on What's Up With Us. When is our What's Up With Us next month? Well, Thursday, May 16th, the day before the Indian Law webinar and live event. Again, 12 o'clock. If you got comments, questions, you want to be interviewed, you've got good ideas for somebody you think we should interview, contact me or Michael. And again, you're here today, watch your email for your certificate for 1 hour of free MCLE. That's it for me, Michael. I want to thank Ben. Michael, why don't you take us out?
All right. Well, thank you for joining. And I'm open to questions. Whatever, if you guys have anything, send me an email. And this upcoming webinar with Michelle will be excellent. We interviewed her in December. And remember, we did the land acknowledgement, which was new to you, and indigenous legal issues are something that's a really big issue in Canada, and it's a big issue in California. And you know where else is a big issue? Everywhere in the United States, because originally it was all owned by the various indigenous tribes. That's all I want to say.
Ben, thank you so much for joining us. We really appreciate your
you guys for
insight
having
and
me.
the information about your practice.
I hope my dogs weren't too annoying, and I really appreciate you guys having me
Thank you,
They are
everybody.
welcome guests.
on. Do they get credit?
Of course,
Yeah,
a doggy bone.
Thanks, guys.
Thank you.
Bye, everybody.
Bye-bye. All right, thanks.